Hi, my name is Cynthia Carroll, and I've been practicing consumer bankruptcy law in Delaware for over 25 years. And I want to talk about the 7 mistakes that people often make before they file bankruptcy. I'm telling you about them because I want you to avoid them. The first mistake to avoid before filing bankruptcy is called the credit card run-up mistake. And oftentimes people will go and run up their credit cards and then come into a bankruptcy lawyer's office to file bankruptcy. Well, if you charge more than $675 within 90 days of filing bankruptcy, or take out $900 or more in cash advances within 70 days of filing bankruptcy, and they are for luxury items, those transactions are presumptively fraudulent and could prevent you from discharging that debt in bankruptcy. So don't do that. Don't jeopardize your fresh start for that type of transaction. The second mistake people make is the repay a family member mistake. You see, the bankruptcy law does not allow you to discriminate between unsecured creditors. So if you have to treat your family member that you owe debt to the same as any other creditor. And if you do that within a year of filing bankruptcy, the bankruptcy trustee can go back and undo that transaction. So that's the second mistake I want you to avoid prior to filing bankruptcy. The third mistake is what I call the liquidate your retirement account mistake. And a lot of times people, in a futile attempt to deal with their debt, will liquidate their retirement account. And if you have a retirement account and it's ERISA qualified, most 401ks, most 403bs, IRAs, other retirement accounts fall into that category. In Delaware, they're 100% exempt. So that's a mistake to go drain your retirement account to pay off debt, only to get back in debt and have to file bankruptcy and then have nothing to retire on. The fourth mistake is called transfer property out of your name mistake. And I get asked this a lot. People will say, well, I have this car, should I transfer it into my daughter's name? No, don't do that. The trustee can go back and undo those transactions within 2 years of filing bankruptcy. Any transaction that's done with the intent to hinder, delay, or defraud a creditor is a fraudulent transfer. In Delaware, it's 4 years. That is a transaction that can be undone by the trustee, so you don't want to do that. Also, you want to avoid making extravagant, questionable purchases within 6 months prior to filing bankruptcy. The fifth mistake is what I call the line of credit second mortgage mistake. A lot of times people will take out second mortgages to pay off debt or to reduce their equity. In Delaware, you can exempt up to $125,000 of equity in your personal residence, and you can take an additional 10% cost of sale, which is 10% of the value of that property. A lot of times people make the mistake of taking out second mortgages. It's like taking unsecured debt that can be discharged in bankruptcy and converting it into secured debt, secured by your home, which puts your house in jeopardy. And I can't tell you the times that I have seen people lose their homes because they have second mortgages. If you think about it, if you had a hard time making ends meet with only one mortgage, it's not going to get any better having 2 mortgages. So that's the fifth mistake that I want you to avoid prior to filing bankruptcy. The sixth mistake is failing to attend court proceedings. Now, just because you're planning to file bankruptcy, that does not stop a court proceeding. You have to be filed and actually have a case number. And most attorneys aren't going to do that until they're fully retained under the terms of the agreement that you're going to have with that attorney. The best thing to do if you're facing a lawsuit and you're making preparations to file bankruptcy, go ahead and file an answer to that lawsuit and get a court date and let your attorney know about it so that your bankruptcy case can be filed prior to that court date. The seventh mistake is failing to disclose the truth, the whole truth, and nothing but the truth to your attorney. Now, your bankruptcy attorneys can only help you if they know what's happening. If you fail to disclose something, that could lead to a loss of your asset. It could lead to other things. So make sure you disclose it to the attorney. The attorney can more often than not help you do some planning to see what could be done to deal with your with that situation. And the final thing I want to say, don't bank with Wells Fargo if you're planning to file bankruptcy, because they will put a freeze on your account, and oftentimes we can't even get that lifted until we have the trustee sign something. So I would say the best thing to do is to avoid having any money with Wells Fargo. If you are going to file bankruptcy and you have a Wells Fargo account, I would recommend that you open up an account at another institution and have your direct deposit going into that new account. Along those same lines, if you owe money to a creditor and you're banking with them, they can exercise what's called a right of set-off and use the funds in your account to pay that debt, especially if it's an unsecured debt. So that's just a bonus for me. I want you to consider opening up a different account if you're planning to file bankruptcy and you have that circumstance. So be sure to like this video, be sure to subscribe to my channel, and I will see you in the next video. Thank you.